A Supreme Court decision just dropped that could decide the fate of your R-15, and right now every sign is pointing in a direction that should worry every gun owner in America. Before we dive in, do me one favor. Hit that subscribe button right now. Now, why? Because 90% of gun owners miss critical legal updates like this, and I don't want you to be one of them. Quick question before we continue. Are you subscribed? Because what I'm about to reveal could decide whether you can keep the rifle you already own. Hit that button now. Here's what just happened. On June 2, 2025, the Supreme Court made a decision, and for gun owners, it was a bad one. The case is called Snope v. Bruen. It came out of Maryland, and it was all about a state law that bans something called assault weapons. Now let me break that down in plain English. Maryland passed a law that makes it illegal to buy or own certain semi-automatic rifles. A semi-automatic rifle loads a new round automatically after you pull the trigger. You pull once, it fires once, and the next round is ready to go. The R-15 is the most famous example. That's the rifle people argue about the most. Here's how the law works. Maryland says you can't buy these rifles unless you already owned one before October 1, 2013. If you didn't own one by that date, you're out of luck. You can't buy one new, you can't buy one used, you can't bring one in from another state. The law even lists certain rifles by name, and it has a list of features. If a rifle has a detachable magazine, plus a pistol grip, plus a flash suppressor, it's banned. That's the kind of detail that makes lawyers happy and normal people confused. Let me explain what those words mean. A detachable magazine is the part that holds the bullets. You can pop it out and put in a new one. A pistol grip is the part you hold that angles your hand like you're holding a handgun. A flash suppressor is a little device on the end of the barrel that hides the flash when you shoot. Now here's the weird part. None of those features make a gun more powerful. They don't make it shoot faster. They don't make it more deadly. They're just features. But if your rifle has enough of them, Maryland says it's an assault weapon, and that's it. It's banned. Think about what that means for a regular person. Imagine you grew up shooting with your dad. You finally have the money to buy your own rifle. You walk into a gun store in Maryland, and the answer is no, not because you did anything wrong, not because you're a criminal, just because of the date you were born into. You missed the cutoff by years, and now the rifle that millions of Americans own is off limits to you. That's the reality of this law. So a group called the Second Amendment Foundation filed a lawsuit back in 2021. They said this law breaks the Second Amendment. That's the part of the Constitution that protects your right to keep and bear arms. The case went up through the courts. A federal appeals court called the Fourth Circuit looked at it. That court covers Maryland, Virginia, West Virginia, and the Carolinas. And here's the bad part. The Fourth Circuit said the ban is okay. It said these rifles are not protected by the Second Amendment. So the case went to the Supreme Court, and on June 2, 2025, the Supreme Court said no, they refused to hear the case. In legal terms, they denied certiorari. That's a fancy word that just means we won't take this case. When the Supreme Court denies cert, the lower court's ruling stands, so the Fourth Circuit's ruling stays, and Maryland's assault weapons ban stays. For now. Now this is where it gets interesting, because the Supreme Court doesn't just say no for no reason. 3 justices wanted to hear this case. Justice Thomas, Justice Alito, Justice Gorsuch. They all said the court should take it. That's 3 votes, but the court uses something called the Rule of 4. It takes for justices to agree to hear a case, so this was 1 vote short, 1 vote. That's how close this was. But wait, there's something even more important. Justice Kavanaugh wrote a separate statement. In plain English, he said the Fourth Circuit's ruling is questionable under the court's own rules. That's a really strong thing for a justice to say. He basically said the lower court probably got it wrong, but he still voted to deny the case, and he said the court should deal with the R-15 question in the next term or 2. That's a hint, a big hint. So here's the picture. All the signs pointed toward the Supreme Court taking this case. 3 justices wanted it. 1 justice said the lower ruling was questionable, but the court still said, no, that's what I mean when I say all signs point to a bad ruling. The signs were all there, and the ruling went the wrong way anyway. Let me explain why this matters to you. The whole fight comes down to a legal test. It comes from a famous case called Heller that was decided back in 2008. In Heller, the Supreme Court said the Second Amendment protects weapons that are in common use by law-abiding citizens for lawful purposes. That's the key phrase, common use. If a weapon is common, if lots of law-abiding people own it, then the government can't just ban it. Then in 2022, the court added another layer in a case called Bruen, and it set the test the lower courts use today. Under Bruen, a gun law has to match the historical tradition of this country. If the founders didn't have a similar law back in the 1700s, then the modern law is probably unconstitutional. That sounds simple. But the lower courts have been fighting over what it means ever since. So let's ask the obvious question, is the AR-15 in common use? Yes, it's one of the most popular rifles in America. Millions of Americans own them. They're used for self-defense, for hunting, for sport, for competition. By any normal measure, the AR-15 is extremely common. So under the Heller test, it should be protected. That's what the gun owners argued. They said, if the most popular rifle in the country isn't in common use, then what does that phrase even mean? But here's what the lower courts said back. They said these rifles are too dangerous. They said they're most useful for military purposes, so they're not protected, and they pointed to another Supreme Court case from way back in 1939. That case is called Miller. In Miller, the court said the Second Amendment doesn't protect weapons that aren't useful for militia service. The lower court latched onto that. They said the AR-15 is a military weapon, so it's not protected, and they said the same thing about magazines that hold more than 10 rounds. Those are called large-capacity magazines. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Okay, back to the story. Here's the crazy part. The courts keep saying these guns aren't protected, but the Supreme Court said in Heller that common weapons are protected, and the AR-15 is about as common as a rifle gets. So how do you square that? The lower courts are basically saying, yes, it's common, but it's too dangerous, so we ban it anyway, and that's a direct challenge to the Heller test. If you're finding this helpful, imagine what you'll learn. In my next video, I'm covering the exact words to say when police ask about your gun. Subscribe so you don't miss it. And it's not just Maryland. The same fight is happening all over the country. In Illinois, a court called the Seventh Circuit upheld a similar ban in a case called Bevis v. City of Naperville. In California, the Ninth Circuit upheld a ban on large-capacity magazines in a case called Duncan v. Bonta that was decided in March 2025. The Ninth Circuit said those magazines are not protected either, so the pattern is clear. Courts all over the country are upholding these bans. Now here's something most people don't realize. Different courts are answering the same question in different ways. Some courts say these rifles are protected, some courts say they're not. That's called a circuit split. And when the lower courts disagree like this, it puts pressure on the Supreme Court to step in and settle it, because you shouldn't lose your rights just because you live on one side of a state line. That's exactly the kind of mess the Supreme Court is supposed to clean up, and for a long time it looked like they were going to, but then they said no, and that's why this ruling felt so bad. That's why this fight is so important. It's not about one state. It's about the whole country. If the courts can ban the most popular rifle in America, what's next? That's the question nobody wants to answer. Here's the part nobody's talking about. Most people think this fight is over. They heard the Supreme Court said no in 2025. They figured, well, that's that. The bans are here to stay, but that's wrong. And this is where the story takes a turn. Remember what Justice Kavanaugh said? He said the court should address the AR-15 issue in the next term or two. Well, he was right. On June 30, 2026, the Supreme Court did something big. They agreed to hear two new cases about semi-automatic rifles. One is called Viramontes v. Cook County. That one comes out of Illinois. Cook County is the county that includes Chicago. The other is called Grant v. Higgins. That one comes out of Connecticut. Connecticut passed its ban after the Sandy Hook shooting back in 2012. That's the shooting where 20 children and 6 adults were killed at an elementary school. The court took both cases and combined them into one. In legal terms, they consolidated them. They'll be argued together this fall. So here's what that means. The exact question the court refused to answer in 2025 is back on the table. Whether the Second Amendment protects our 15 platform rifles that are in common use. The court is going to answer it. This fall, the lawyers will stand up and argue, and sometime after that, the court will rule, and that ruling could change everything. Let me explain. What happens next? When the court hears a case, the lawyers get a set amount of time to argue. In these two cases, they get 1 hour total. That's a sign the court thinks they're really similar. After the arguments, the justices meet in private, they vote, and then someone writes the opinion. That takes months. So realistically, a decision could come in the spring or summer of next year. That means you have time, but not forever. And the clock is already running, and there's more waiting in the wings. 3 other big cases are sitting at the Supreme Court's door. They're called Duncan v. Bonta, Gators Custom Guns v. Washington, and Nager v. Lamont. They deal with magazine bans and more rifle bans. The court hasn't decided whether to take them yet. They're waiting for the long conference in late September 2026. That's a fancy way of saying the justices will meet and decide what to do. So this fall is huge. Not one case, a whole wave of them. And here's why the magazine cases matter so much. Even if the rifle cases go our way, the magazine cases could still go the other way. A magazine is the part that feeds the bullets into the gun. If the court says magazines over 10 rounds aren't protected, then a rifle you can still own might be useless without a legal magazine. So these cases are connected. They're all part of one big fight. And that's why you can't just watch one of them and ignore the rest. You need the whole picture. And that's exactly what this channel gives you. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let me be honest with you. This could go either way. Here's a hypothetical example to explain this. Imagine the court rules against us. Imagine. They say these rifles are not protected. Then every state that wants to ban them can do it. Maryland's ban stays, Illinois' ban stays, Connecticut's ban stays, and new states can pass their own bans tomorrow. If you live in one of those states, your rifle could become illegal to own. You'd have to sell it, or register it, or get rid of it. That's the worst case. But here's the other side. Imagine the court rules for us. Imagine they say, the AR-15 is in common use and it's protected. Then all these bans start falling. Maryland's ban falls, Illinois' ban falls, California's magazine ban falls, and gun owners across the country win a huge victory. That's the best case. So which way are the signs pointing? Honestly, it's mixed. The lower courts have mostly upheld these bans. The Supreme Court has been careful, even cautious. But remember, they just struck down a Hawaii law in June 2026. That case is called Wolford v. Lopez. The court said Hawaii couldn't stop licensed gun owners from carrying on private property. That was a win for gun owners. So the court is not always against us. But on rifles, the signs are harder to read. That's why you need to pay attention. Let me give you a real scenario so you feel why this matters. Imagine you live in a state with one of these bans. You bought your rifle legally years ago. You shoot it at the range. You use it for home defense. You've never broken a law in your life. Then one day, the court rules against us, and your state decides to tighten the law even more. Suddenly, the rifle you've owned for years is a problem. You have to figure out what to do with it. Sell it? Turn it in? Register it? Nobody tells you. You're on your own. That's the reality people don't think about until it happens to them. Now here's what most people get wrong. When news like this drops, people do two dumb things. First, they panic. They rush out and sell their rifle for cheap. They think the ban is coming tomorrow. Second, they do nothing. They figure it'll never affect them. Both of those are mistakes. Here's what you should actually do. First thing, don't panic. Sell. A ruling hasn't happened yet. The cases are just being argued this fall. If you sell your rifle now out of fear, you lose money and you lose your gun for nothing. Wait for the actual decision. Second, don't panic by either. Some people think, I better buy before the ban. That's also risky. If the court upholds the bans, you just spent a lot of money on a rifle you might not be able to keep. And buying under pressure is how people make bad choices. Third, know your own state's laws. The Supreme Court case is national, but your daily life is local. What's legal in Texas might be illegal in Maryland. Don't assume the national news applies to your street. Check your state's rules. If you're not sure, that's exactly when you talk to a lawyer who knows gun law in your state. Fourth, keep your paperwork clean. If you own a rifle, keep your receipts, keep your registration. Keep everything documented. If a law changes, having clean records makes everything easier. It's boring, but it protects you. And here's the thing nobody says. Whatever the court decides, the law doesn't change overnight in a way that catches you by surprise. There's usually a grace period. States have to figure out how to apply the ruling. That gives you time, but only if you're paying attention. And that's the whole point of this channel, to make sure you're paying attention before it matters. The clock is ticking. Arguments happen this fall. The ruling could drop before the year is over. Subscribe now because the next video breaks down exactly what to do before that decision lands. If you're not subscribed, you'll miss it. And by the time you find out, it might be too late. So let's wrap this up. Here's the takeaway. In 2025, the Supreme Court refused to hear the AR-15 case. That was a bad ruling for gun owners. Maryland's ban stayed. But the fight didn't end. In 2026, the court took the case back. This fall, they'll argue it. And after that, they'll decide. That decision could protect your rifle or it could take it away. The signs are mixed. So don't guess. Don't panic. Stay informed. Look, I spend hours digging through court rulings so you don't have to. That's what this channel is for. The least you can do is hit that subscribe button. It's free, it takes 2 seconds, and it means you'll never miss a ruling that affects your rights. Deal? One last thing, and this is important. I'm not a lawyer. This video is educational information, not legal advice. Every case is different. Every state is different. If you have a real legal question, talk to a real attorney. Don't take legal advice from a YouTube video, even mine. Stay safe out there.